Imagine standing in court with a choice that could change your life forever. Take a deal for just a few years, or risk decades behind bars. What happens next in this hearing isn't just tense. It's a decision that could cost everything.
Are you Krista Arredondo? Arredondo, you need to speak up so I can hear your name on the record. Speak again, please. I could barely hear you. Arredondo appears to be in a motor vehicle. It appears that she's on the passenger side from the view I have, but I'll make sure and clarify that with her.
Okay, I believe I'm good now. I apologize about that.
Mr. Arredondo, you are not
I am on No, I am on the passenger side. You were correct.
All right.
And I just put my seatbelt on.
All right, Mr. Arredondo, we're here for a status conference. Can I be assured that you've been able to maintain very good and close contact with your attorney?
I can always do better, for sure. But yes, I've been in contact with him.
That's somewhat concerning to me, Ms. Arredondo. And the reason for that is probably obvious to you, but I'll make it more obvious. This is a final status conference and a plea cutoff, meaning it's the last opportunity that I'm providing to you to consider plea offers. If you don't plea, that's fine. You're not entitled to consider, you don't have to consider any plea offers. But if we get past today and no pleas are entered, you're going to be going to trial, and that trial is on May 20th and 21st. And the jury's going to determine whether or not the prosecutor can meet its burden of proving your guilt on any or all of the charges. Do you understand all of that?
I understand.
Those charges are significant. 3 separate charges of delivery or manufacture of the methamphetamine or cocaine. It looks like, I'm sorry, I misspoke. It was cocaine in count 1, cocaine in count 2, and heroin or fentanyl in count 3. All of those are 20-year maximum felonies. And because your charge is a habitual offender third offense notice, that makes the maximum penalty 40 years in the state prison system. Are you aware of that?
Yep, I'm aware.
So when you tell me that you could do better being in contact with your attorney in light of the nature of the charges, their maximum penalty, and your newly and soon impending trial date, you can probably understand why that gives me concerns.
Well, I mean, I have been in contact with him, and we are in an understanding of each other, and we are going to be in contact from here until then, so it's not going to be a concern.
All right. Well, if you don't think there's a concern, then I'm going to not be as concerned as I was initially. Mr. Brown, do you think that you're ready to proceed one way or the other today and or into the future?
I am, Your Honor. However, I would like to make a record here as well regarding the communication. It has been very sparse and sporadic. Generally, it is via email. There are multiple phone numbers that I do have on file. Those are all disconnected. I did, and I am hoping that Ms. Arredondo can do this, especially with trial approaching. Email is good. It's some communication, but it is not the way I prefer to communicate. It is just not real time. So if she could get a good phone number, I am going to have to be in contact with her.
My phone was temporary off. It is correct. It is back on. It's good to go. It's not going to be a problem.
Okay.
Does that allay your concerns, Mr. Brown?
Yes, Your Honor.
So what is the status of the case in terms of how you think we should be proceeding, Mr. Brown?
I have gone over the plea offer with Ms. Arredondo on different occasions, Your Honor, and we are going to proceed with trial.
And for the record, Ms. Brooker, can you state what the terms of the latest plea offer were, just so that it's on the record?
Yes, Your Honor. Give me 1 second.
I thought they were.
Be sure to scroll it in. me go back. The offer is for her to plead to count 1, dismiss counts 2 and 3, and the drug double and habitual notice.
So, Mr. Brown, my last indication, at least from my notes, was on January 8th of 2026. The offer that Ms. Redondo had rejected was a simple possession, a 4-year maximum. Has that changed, Ms. Brooker, since January 8th? Because it sounds like the plea offer you're suggesting is
I'm
much more.
sorry, Judge, I just want to make sure. If that's what Mr. Rolla said on January 8th, Judge, then the offer that was stated on January 8th is the plea offer.
I can only say that's what my notes reflect. I generally have good notes, but Mr. Brown, can you help me update?
That's what I went over with Ms. Redondo.
the
That's
possession?
correct. There's another note here that indicated that, the offer would be to an added count 4 possession, dismiss 1 through 3, and the drug double and habitual third.
All right, Ms. Arredondo, were you able to hear that?
I was gonna ask if you could repeat what that offer was completely in full, the
Of course.
stipulations.
Of course. So there is no stipulations other than the terms of a plea agreement, but the plea agreement would be that if you pled guilty to it, what's called an added count 4, added count meaning you're not charged with it right now, but it would be added for purposes of a plea. That added count would be possession of the controlled substance cocaine. Possession of the controlled substance cocaine is a felony with a maximum punishment of 4 years in the state prison system and or a fine of up to $25,000. And then the benefit would be if you pled guilty to possession of cocaine, the prosecutor dismissed all of the other charges and all of the other enhancements. In other words, those 40-year maximum offenses that you're facing for count 1, count 2, and count 3 would all be dismissed if you pled guilty to the possession. Do you understand that now?
Okay, I understand that part. And, so I just gotta plead guilty to a possession charge.
You don't
That's
have
it?
to. You
I
don't
mean,
have to.
like, because I remember some plea they offered me, there was some, I had to like agree to do drug court down here and like go tell on some people or something. And I don't know. Is that the same?
Are there any other terms of the plea agreement, Ms. Brooker, that you're aware of?
That was something that we had discussed in district court, and that is not a part of the. plea.
Okay.
That was it discussed with a further reduction if she had done drug court, but since the prelim went, that's not.
So, Ms. Arredondo, the indication from the prosecutor's office, and Mr. Brown, is that accurate?
Yes, Your Honor.
And from your attorney is that that was a discussion prior, but it's not a part of this plea agreement. This plea agreement, if you wanted to take advantage, would call for you pleading guilty to possession of cocaine for dismissal of all of the existing charges. Do you understand that?
Yes.
Do you understand the difference between that possession charge, a 4-year max, and if you were convicted at trial on the delivery charges 1, 2, or 3, and the habitual offender third offense notice, at least as it's alleged by the prosecutor?
Yeah, I understand. Do I have to make that? Do I have to decide right now, or can I talk to my lawyer?
Ms. Arredondo, if you would have talked with your lawyer before, and when you talked to your lawyer on January 8th of 2026, and if you would have kept in that better communication, you would have already had these questions resolved. And so while I generally am sensitive to your decision to talk more, this has been set for months as a final status conference and plea cutoff. If you wanted to talk options with your attorney, you could have done so. Your failure to do so is not excused by the court right now. So I recognize that puts you in a position of needing to decide, but the record is clear that you've known of this need to decide for months. So it does not matter to me how you proceed, but you need to make the decision.
I'm pretty confident going with trial.
All right. Mr. Brown, any further things you wanted to state on the record?
No, Your Honor, thank you.
Mr. Brooker, anything further you wanted to state on the trial, on the record in terms of the plea offer?
No, Your Honor.
So, Mr. Arredondo, you're entitled to trial. We'll have you set for trial, and the jury will determine all of the issues in this matter. My rule and requirement for the attorneys and for you is that you and the attorneys are here no later than 8:30 on the morning of your trial dates. Those trial dates, again, are May 20th and May 21st. Do you understand?
I understand.
So you need to be here in the Otsego County Circuit Courtroom on those dates no later than 8:30 in the morning. Do you have any questions about any of that?
No, Your Honor.
From today forward, it is my specific order to you to be routinely and consistently in contact with Mr. Brown. The reason is there are a lot of things that need to be done from the defense side and the prosecution side to fully prepare for trial in this next month or so. Do you understand?
I understand.
From counsel's standpoint, first on behalf of the people, are there other issues the court should be aware of in preparing for trial?
I don't believe so.
From the defense side?
No, Your Honor.
The court will keep these trial dates on then. I'll remind attorneys, and I know you know this, but at least 14 days before trial, I need full text jury instructions from each of you, fully tailored to the case and ready to present to the jury. Anything else before we break, Ms. Crooker?
No, Your Honor.
Mr. Brown?
No, Your Honor.
Ms. Arredondo, do you have any questions before we break?
No, Your Honor.
The court will see you at your trial no later than 8:30 in the morning.
One decision, that's all it took. Now the deal is off the table, and everything rides on the trial. The real question is, was this confidence or a mistake she'll regret for the rest of her life?